Imagine investing your hard earned money in an IPO after reading a prospectus that promises growth, expansion, profitability, and strong future potential. But later you discover that critical information was false, hidden, or manipulated. Investors lose crores. Share prices collapse. Regulators begin investigation. Directors panic. Merchant bankers face scrutiny. Auditors are questioned, and suddenly one dangerous legal question arises. Who will compensate investors for losses caused by a misleading prospectus? Today, we are entering one of the most powerful investor protection provisions under the Companies Act 2013, Section 33. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today we are discussing Section 33 of the Companies Act 2013, Issue of Application Forms for Securities. At first glance, this provision may appear technical and procedural, but in actual corporate governance and securities law practice, Section 33 plays a crucial role in ensuring that investors apply for securities only after receiving access to legally compliant prospectus disclosures. This provision directly protects transparency, informed investment decisions, and market integrity. For advocates handling securities disputes, company secretaries managing public issue compliances, chartered accountants reviewing disclosure systems, CMA professionals analyzing issue structures, directors approving fundraising activities, and investors participating in IPOs, Section 33 becomes extremely important. To understand Section 33 properly, we must first understand a basic but very powerful principle of securities law. An investor should never be asked to invest blindly. Before applying for shares or debentures, investors must receive access to material disclosures regarding the company, risks, financial condition, business model, litigation exposure, objects of the issue, and governance structure. This is the foundation of informed consent in capital markets. Section 33 strengthens this principle. Now let us understand the core legal structure. Section 33 provides that no form for application for purchase of securities shall be issued unless such form is accompanied by an abridged prospectus. This requirement is extremely important. The law does not permit companies to casually distribute application forms without disclosure access. An investor applying for securities must receive key summarized disclosures through abridged prospectus. Now let us understand the meaning of abridged prospectus. An abridged prospectus is not the full prospectus. It is a summarized version containing the essential features of the prospectus in prescribed form. This creates practical balance. A full prospectus can be extremely lengthy and technical. Retail investors may not immediately read hundreds of pages. The abridged prospectus therefore provides concise but meaningful disclosure access at the application stage. This reflects a very important legislative philosophy. Disclosure should not merely exist formally, it should be accessible practically. Now let us discuss the historical background. In earlier periods of securities market evolution, investors were often persuaded to subscribe through aggressive marketing without receiving meaningful disclosures. Application forms circulated independently. Risk factors remained hidden. Important financial weaknesses were ignored. Retail investors suffered major losses. Modern corporate and securities laws therefore evolved toward mandatory disclosure, integration with investment solicitation. Section 33 reflects this investor protection philosophy. Now let us understand the relationship between Section 33 and prospectus regulation generally. Sections relating to prospectus disclosures create substantive transparency obligations. Section 33 operationalizes investor access to those disclosures at the application stage. This is extremely important. A prospectus locked away somewhere without investor accessibility defeats the purpose of disclosure regulation. Section 33 ensures practical connectivity between investor applications and disclosure documents. Now let us discuss the role of SEBI. In modern capital markets, SEBI regulations heavily govern issue processes, application systems, and investor communications. SEBI ICDR regulations prescribe detailed disclosure norms, including contents and format requirements for abridged prospectus. Section 33 operates alongside the securities law framework. Professionals must therefore understand both company law and SEBI regulations together. Now let us discuss practical application. Suppose a company launches a public issue and distributes application forms through brokers, banks, digital platforms, or collection centers. The investor must receive access to abridged prospectus disclosures. Without the safeguard, investors could unknowingly apply based only on advertisements or market hype. This becomes dangerous. Now let us discuss digital transformation. Modern IPO applications increasingly occur online through ASBA systems, UPI applications, and electronic platforms. Many people assume Section 33 became irrelevant after digitalization. That is incorrect. The principle remains fully relevant. Even in digital systems, investors must receive access to disclosure documents before investment decisions. Technology changes the mode of access, not the disclosure obligation itself. Now let us discuss the practical meaning of application form. Traditionally, this referred to physical forms used for security subscription. Today, it includes electronic application interfaces and digital subscription mechanisms. Professionals must understand the provision dynamically in light of evolving market infrastructure. Now let us discuss exemptions and practical exceptions. In certain situations prescribed under law or securities regulations, abridged prospectus requirements may operate differently depending upon issue structure and mode of communication. Professionals must carefully verify current SEBI circulars and MCA requirements. Students should avoid oversimplified interpretation. Now let us discuss the governance philosophy. Section 33 protects informed investor participation. This is one of the core pillars of securities regulation globally. The law assumes that investors can make their own commercial decisions, but only if adequate disclosures are accessible. This disclosure-based regulatory philosophy is fundamental to modern capital markets. Now let us discuss board governance aspects. Before public issue launch, board meetings become highly important. The board approves issue documents, application processes, abridged prospectus circulation, and compliance frameworks. Directors must ensure investor communication systems are legally compliant. Passive approval culture creates governance risk. Now let us discuss the role of company secretaries. The company secretary becomes one of the most critical compliance coordinators during public issue processes. The CS ensures that application mechanisms, disclosure circulation, ROC filings, and regulatory timelines are properly aligned. Coordination with merchant bankers, registrars, legal advisors, and stock exchanges becomes highly sensitive. Now let us discuss ROC filing perspectives. The prospectus and related documents must be filed with the registrar according to statutory requirements. Professionals must ensure consistency between the full prospectus and abridged prospectus. One common practical mistake involves mismatch in disclosures between the detailed prospectus and summarized version. This creates legal and governance risk. Now let us discuss practical investor behavior. Retail investors often rely heavily on simplified disclosure documents. Many do not initially read the full prospectus. Therefore, the abridged prospectus becomes extremely important from investor protection perspective. If material risks are diluted excessively during summarization, investors may receive distorted understanding. This is why drafting integrity becomes critical. Now let us discuss practical examples. Suppose a company has substantial litigation exposure, debt pressure, and regulatory dependency. If the abridged prospectus highlights only growth opportunities while minimizing key risks, investor understanding becomes incomplete. This can later trigger litigation and regulatory scrutiny. Now imagine another situation. A company circulates application forms rapidly through digital channels but fails to ensure proper investor access to disclosure documents. Questions may arise regarding procedural compliance and investor protection standards. Now let us discuss hidden academic and professional traps. Many students assume a bridge prospectus means merely a short advertisement. That is incorrect. It is a legally regulated disclosure document. Another hidden trap involves assuming the provision concerns only physical forms. Modern interpretation includes digital application environments as well. Now let us discuss the role of merchant bankers. Merchant bankers supervise issue management, disclosure coordination, and investor communication processes. They conduct due diligence regarding prospectus disclosures and application systems. Any compliance gap may expose intermediaries to scrutiny. Now let us discuss drafting precautions. The abridged prospectus must accurately summarize material disclosures. Risk factors should not disappear during simplification. Financial highlights should remain consistent. Issue objectives should be clearly explained. Litigation disclosures should not become misleadingly vague. Professional drafting discipline becomes extremely important. Now let us discuss penalties and legal implications. If application forms are issued in violation of statutory requirements, companies and officers may face penalties and regulatory consequences. Where misleading disclosures exist, broader liability provisions may also become relevant. Investor litigation exposure may arise depending upon facts. Now let us discuss practical due diligence perspectives. During securities law audits, IPO due diligence and governance reviews, professionals examine whether investor application systems complied properly with disclosure requirements. Weak compliance processes may indicate broader governance deficiencies. Now let us discuss the connection with other provisions. Section 33 closely interacts with prospectus provisions, liability provisions, advertisement regulations, and SEBI disclosure frameworks. It also connects practically with investor grievance mechanisms and public issue governance systems. Students should understand this integrated structure carefully. Now let us discuss the role of advocates. Advocates analyze disclosure adequacy, litigation exposure, and securities law compliance. In investor disputes, courts may examine whether proper disclosure access existed before applications were made. This makes Section 33 practically significant in litigation analysis. Now let us discuss the role of chartered accountants and CMA professionals. Financial summaries inside abridged prospectus must remain accurate and balanced. Revenue figures, profitability trends, liabilities, and issue utilization details must reconcile properly with the full prospectus. Financial inconsistency can damage credibility severely. Now let us discuss applicability across company categories. Public companies issuing securities to the public face primary applicability. Listed companies conducting public issues are heavily affected. Private companies generally do not issue securities through public prospectus systems in the same manner. OPCs and dormant companies usually encounter limited practical relevance unless transitioning toward broader capital structures. Now, let us discuss governance culture. Strong governance environments prioritize transparent investor communication. Weak governance systems sometimes treat disclosure compliance as mere formality. That difference becomes visible during fundraising quality. Institutional investors carefully evaluate disclosure culture and transparency discipline. Now, let us discuss practical case study style illustrations. Imagine a startup entering IPO markets with strong branding and media excitement. Retail investors rush to apply. However, the Abridged Prospectus properly discloses heavy dependence on a few customers, cash burn concerns, and regulatory uncertainties. Some investors reconsider after reading disclosures carefully. This demonstrates the real protective value of Section 33. Now, imagine another scenario. A company uses highly aggressive promotional campaigns but provides poor quality abridged disclosures with inadequate risk explanation. Later, financial problems emerge. Investors may allege they were not adequately informed before applying. Again, disclosure integrity becomes central. Now, let us discuss the broader economic philosophy. Efficient capital markets require investor trust. Investors participate confidently only when they believe disclosure systems are reliable and accessible. Section 33 strengthens this confidence by ensuring disclosure access at the application stage itself. Now, let us discuss secretarial audit perspectives. Secretarial auditors reviewing public issue compliance often examine whether application procedures, disclosure circulation, and statutory requirements were properly followed. Documentation quality becomes important governance evidence. Now, let us discuss examination insights. Students should clearly distinguish between full prospectus and abridged prospectus. Another important concept involves understanding why disclosure accessibility matters in securities law. Professional examinations frequently test practical understanding of investor protection philosophy. Now, let us discuss practical compliance tips. Always maintain consistency between full prospectus and abridged prospectus. Ensure investor accessibility across digital and physical channels. Review risk factor summarization carefully. Preserve issue documentation properly. Coordinate closely with merchant bankers and legal advisors. Monitor regulatory updates continuously. These practices significantly improve governance quality. Now, let us discuss the future perspective. As digital investing grows rapidly, disclosure accessibility will become even more important. Investors increasingly consume information through mobile applications and electronic systems. The underlying principle of Section 33 therefore remains highly relevant even in advanced digital securities ecosystems. Now, let us conclude with the most important governance insight. Section 33 is not merely about attaching abridged prospectus with application forms. It is about protecting informed investment decision making. It ensures that investors are not asked to commit money blindly without access to essential disclosures. For company secretaries, this provision represents a critical investor communication compliance area. For advocates, it becomes relevant in securities litigation and disclosure disputes. For chartered accountants and CMAs, it intersects with financial disclosure integrity. For directors, it creates accountability toward transparent fundraising practices. And for investors, it serves as a powerful reminder that every investment application should be supported by careful review of disclosure documents. Ultimately, Section 33 teaches one foundational principle of modern securities regulation. Investor confidence is built not through marketing excitement alone, but through accessible, truthful, and legally compliant disclosure systems under the Companies Act 2013. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.